Estate Planning for Boomers. My name is Rob Morris. I'm chair of the Trust and Estates Department at Stark & Stark. Before we begin, I'd like to give you a little bit of information about our firm. Stark & Stark is a full-service law firm. We offer everything from estate planning, of course, which is what we're going to discuss today, to business and transactional, landlord-tenant, real estate, and of course, personal injury and others. If you have any legal questions as a general matter, please feel free to contact our firm or me. There's a phone number on this slide. I'm just going to read my phone number off, 609-945-7617. Please feel free to call me. That's my direct line. You're also welcome to email me at rmorris@stark-stark.com. Okay, so today we're going to talk about estate planning for boomers. The first group of issues that we're going to discuss will be some of the quote new end quote issues that face baby boomers. I put new in quotes because to some degree some of these issues are old. However, there are new twists on them that some of our baby boomers are now starting to face. We're then going to talk about taxes. And lastly, we're going to discuss a few estate planning opportunities and options. Again, if you have any questions regarding any of the material that we covered today, please feel free to call or email me. Okay, so what are some of these new issues that are facing baby boomers? Just from my perspective, a few of the items that I'm seeing relating to older individuals are, number one, the population is aging. So some individuals are living longer than they used to, which results in a cognitive and an overall energy decline. So as a result of those two factors, that makes these individuals vulnerable, right? So we're starting to see more of a older, vulnerable elderly population. So you're probably wondering, what do I mean by that? Let me give you an example. So we all receive on our cell phones those texts. They're unsolicited. We receive unsolicited phone calls. You know, obviously, for many people, you're able to pick them off as being fraudulent or highly suspect. Either don't answer them or delete them. Unfortunately, what we're seeing with some older individuals is that they are responding to these emails. They're being essentially sucked in by them and attempting to engage with whoever's sending these emails, which obviously presents a huge risk of fraud. This can occur in a number of different contexts. I note on the screen here where you have unsolicited texts and phone calls. Sometimes elderly people will have people that come to their actual doorstep, particularly if they're living on their own. May not necessarily be a fraud or a scam, but it might be somebody who's highly aggressive at selling things. So unfortunately for a lot of older individuals, because of their advanced age, decline in cognitive abilities, they're less able to identify these issues and are more likely to be sucked in by some of these particular scams. Another quote new issue that's facing some boomers is family discord. So what do I mean by that? Unfortunately, with some families, we're starting to see more and more disputes within the family. You see brothers and sisters or sisters that are disagreeing, or brothers that disagree over various items, how mom and dad's money is being handled, what the expenses are, if there's real estate, you know, who can use the vacation home or the real estate, all types of issues. In some more extreme situations, you have one child that has an advantage with mom and dad over another child, so you may see more gifts, transfers, and so forth involving that child. Again, not necessarily a new issue, but one I think that's become certainly more intense over the last 5 years, and particularly over the last few years after COVID. Again, when you have older adults that are aging and are perhaps older than maybe their parents were, they're less able to fight off some of this family discord. So if you happen to have one child that's extremely aggressive with mom and dad, as mom and dad age, they're less able to fend off that child and the wants and desires that come from that child. So again, uh, uh, I guess not necessarily a new issue, but one that certainly is becoming more extreme and that we're noticing more in today's society. So what are some fundamental estate planning documents and how can they help with some of the issues that we discussed? All right, so at a minimum, and again, this may be another issue that boomers face, you don't have any of these documents, right? But at a minimum, you should have a healthcare power of attorney, you should have a power of attorney, you should have a will, and for some people, depending on their circumstances, a revocable trust. And of course, if your estate is larger, you may want to look into irrevocable trusts or other estate planning options, which aren't listed on the slide, but are certainly available for many individuals. But at a minimum, everybody should have a healthcare power of attorney, a power of attorney, and a will. So how can these documents help you? All right, well, let's frame this issue in terms of what the alternatives are. All right, so if you don't have a power of attorney and you don't have a power of attorney for healthcare and you become incapacitated. So what that means is either through advanced age or a disease or an illness or perhaps an accident, you've lost cognitive ability to make decisions on your behalf. So you're now deemed to be incapacitated by the law. So if you don't have a power of attorney or a healthcare power of attorney in place, you're now going to have to go through a guardianship, which is a court proceeding. It's expensive. There are likely to be attorneys involved, certainly for the person filing the guardianship action, whether that's a spouse or a child that's seeking to become a guardian. And there will definitely be a court-appointed attorney to represent the individual who's alleged to be incapacitated. All right, and in some extreme instances where there are disputes or special concerns involved, there may even be a guardian ad litem appointed. So overall, you can see with the involvement of all these different attorneys, the action's expensive. They're also time consuming. All right, so at a minimum, you're probably facing a couple months to have the guardianship put through, unless there are emergent circumstances. And in some more extreme instances where there are disputes among the children or perhaps a spouse and a child as to who the guardian should be, that's going to delay the final resolution of the guardianship even further. So the guardianship action could be months before it's decided by the court. Meanwhile, decisions can't be made unless a temporary guardian's appointed. That's going to just simply add to the cost. And all this could be avoided with a couple simple documents, a power of attorney and a power of attorney for healthcare. So that's partially why these documents are so important to have in place. You can eliminate these expenses and you can hopefully minimize some of the disputes among the family members. If you don't have a will or a revocable trust, then it's likely you're going to face an intestacy. So if you pass away, particularly unexpectedly, and you get into a situation where there are assets, but there's no will or trust to govern the assets, now you're going to be intestate. And again, you're going to face unnecessary expenses. Depending on who your administrator is, it's likely they're going to have to post a bond, and that's going to be thousands and thousands of dollars spent unnecessarily on a bond alone. They're also slower. You have to apply to be appointed, and if there are disputes among some of your heirs, then that's going to delay the action even further. Another result from an intestacy is you may have some inadvertent heirs. There may be some family members that you simply don't want to have inheriting your assets. Well, if you don't have a will or you don't have a trust, you're now at risk where inadvertent heirs could receive your assets. This is particularly true for unmarried cohabitating couples. In that situation, if there's nothing left to the partner, then it's very likely they may receive nothing at all. So again, the alternatives to not having these documents are extremely expensive. During your lifetime, you're potentially looking at a guardianship and a long period of inaction. And if you pass unexpectedly, you're going to be looking at an intestacy with unnecessary expenses and risk of inadvertent errors. All right. So what are some of the lifetime benefits of estate planning documents? In other words, how do these documents work kind of as a general matter, and what can they do to attempt to eliminate some of the issues that we just discussed? So a power of attorney appoints an agent who can assist with your affairs. So again, that's an important definition. The power of attorney appoints an agent, and agents charged under law with doing what you instruct them to do. It doesn't authorize them to go off and do whatever they feel like. Again, the agent's required to abide by your wishes, and if you're incapacitated and you can't express your wishes, then the agent's bound to act in your reasonable best interest. And one of the keys of the power of attorney is you get to pick who these agents are. All right, so obviously if you have a spouse, that individual usually receives heightened priority as an agent. If you have one or more children that you believe would be good agents if your spouse is unavailable, you can certainly designate them as alternates to the spouse on the power of attorney. So these agents are in place under this document and can assist you with your affairs. All right. So again, if you're elderly or you are suffering from diminished capacity, the power of attorney can allow you to have your agent assist you with your affairs. They can pay day-to-day expenses. They can monitor your accounts just to try and flag any issues where you have checks, right? So suppose again you're hit by one of these scams and they want you to write a check and FedEx it down to wherever, right? Where they can receive it and apply to this poor individual who's struggling to make ends meet. Unfortunately, a lot of the frauds act that way. So the power of attorney can monitor the accounts, right? And in extreme situations where you lose complete capacity, the agent under the power of attorney can address those issues directly for you. Similarly, you have a revocable trust. So again, not everybody's going to have a revocable trust, but for some individuals, they make sense, right? And what you can do with a revocable trust is you can retitle your non-qualified accounts. And what I mean by that is if you have assets that are not in a 401k or an IRA, let's just say they're a regular bank account, a regular investment account that's not tax deferred, you can retitle those accounts directly into the trust. And the nice thing about the revocable trust is you can appoint a co-trustee, again, who can be a spouse or a child or some other trusted individual, who can assist you with these accounts. And as co-trustee, or frankly as an agent, they can have access to your accounts. They can monitor the transactions that are going on in these accounts. And if there are any issues that need to be flagged, your co-trustee under the revocable trust or your agent under the power of attorney can act on your behalf to take steps to cut off the fraud. So these are two very important options for dealing with fraud. They're also valuable in the sense that you can appoint these individuals to assist you if and when the time comes, so that if you're struggling with the day-to-day management of your assets, you can appoint the agents or the co-trustees to pay your expenses. They can pay your utility bills, they can pay your property taxes and so forth, and they can help you with your overall affairs so you don't go into a default, you don't miss payments, and overall you don't get yourself into a damaging financial situation. So these are very valuable documents to assist you with your lifetime affairs. Okay, so having talked about some of these special issues, let's shift gears and let's talk about estate and inheritance taxes. So these issues aren't unique to baby boomers. They frankly affect every estate. And it's important to understand what they are so that they don't diminish the value of your estate because you failed to address them or failed to act properly. Okay, so the first taxes I'd like to speak about are the federal estate, gift, and generation skipping transfer taxes. Now, currently there's a unified exemption in 2024 of 13.61 million per person, right? So it's a pretty large exemption. If you have a married couple, you can do the math. You multiply that number by 2, and that's going to put you, if I did the math correctly, at 27.2 million. But please keep in mind that that exemption is only effective in 2024. It's going to be indexed slightly, which means it's likely to increase in 2025 unless we have additional legislation. All right, but these higher exemptions are scheduled to sunset at the end of 25. All right, and if no further legislation is passed, and that's going to be difficult to tell, right, because we're going to have an election between now and then. But if no legislation is passed, the exemption is likely to be cut in roughly half. All right, it's hard to know exactly where it's going to fall out, but a rough estimate might be somewhere in the order of $6 or $7 million per person. All right, so please keep that in mind, particularly if you think it's going to affect your estate. We're going to talk about that in a minute. All right, there's also annual exclusion gifts. A lot of folks still have in their mind, some of the older numbers, $10,000 per person per year. That has been indexed up to $18,000 per person per year. All right, and for some folks, particularly in our area, they may have a non-citizen spouse. You can make gifts to a non-citizen spouse up to a maximum of $185,000 a year. All right, if your spouse is a U.S. citizen, there's an unlimited exemption for U.S. citizen spouses. Again, the $185,000 would only apply if your spouse is a non-citizen. That can be an issue from time to time. Please keep in mind, for example, if you're buying a house and you pay for it, but name your spouse as a tenant by the entirety or a co-owner, you've just made a gift. And if the value of your house is half of it is more than 185,000, you may have a tax issue. So if you're doing any type of gifting, it's important to speak with your CPA and your financial advisor before you undertake that gift. And obviously you can speak to us as well. All right. So the next slide here, I'd like to show you why some of these exemptions, although they sound high, can be an issue, particularly for many people. And what we're going to do is frame this in the context of the Rule of 72. So the Rule of 72 roughly tells you how long it takes your estate to double depending on the rate of return that you're earning. So for example, if you earn a 7% rate of return, you divide 72 by 7, and that would give you about 10.285 years before your money doubles in value. So for example, if you currently have about $2 million in assets, and it's earning 7%, it may double in value each 10.2 years. So in 10 years from now, instead of 2 million, you may have an estate that's worth 4 million. In 20 years from now, instead of 2 million, you may be up around 8 million. All right, now the numbers are getting a little bit more interesting because remember, the estate tax is set to sunset in 2025. All right, and it may come down below the $8 million threshold. So if that occurs, you need to make sure that you have estate planning documents that can handle that, all right, that can allocate your exemptions out efficiently and avoid having your estate taxed, even though you may have, for example, only roughly about 8 million. And if you're able to carry it out to 30 years, returning to the slide here, instead of an $8 million estate, you may be looking at 16 million. And now the discussion's a lot more interesting. You really need to be careful about how you handle your estate tax exemptions. There's also a deceased spouse unutilized exemption transfer for the estate tax. That needs to be kept in mind. So for individuals that have assets of this value, it's very important that you speak to financial advisor, your CPA, and your attorney to make sure that the estate planning documents are done correctly. All right, so those are taxes at the federal level. New Jersey also has death and retirement account taxes. It used to have an estate tax, but that was reduced to 0 in 2018. Again, we don't know what the future is, if that estate tax will come back, but for right now, you don't have to worry about it. New Jersey does still have an inheritance tax on the books, and we're going to talk about how this tax applies in a second. But for unmarried couples or couples that don't have children, the New Jersey inheritance tax is something that you really need to be focusing on. Frankly, for individuals that live in Pennsylvania, there's an inheritance tax in Pennsylvania also, which affects not only uh, more remote relatives, but also your children. So although we're going to focus on the New Jersey inheritance tax, if you live in Pennsylvania, please also keep in mind that it has a similar inheritance tax that also applies to your children. All right, so the New Jersey inheritance tax is unaffected by the 2018 changes. All right, and the tax is based on the class of your beneficiaries. So if you're intending on leaving assets to somebody other than a spouse, child, or grandchild, and so forth, then you really need to be focusing in on this tax. Spouse, children, and grandchildren are Class A beneficiaries. There is no Class B beneficiary, so that's not a typo on the slide. And then there are also C and D beneficiaries. We're going to talk here in a second about who they are and what their tax rates are. So again, Class A beneficiaries, spouse, children, grandchildren, so forth, there's no inheritance tax. Class C beneficiaries, what you're talking about there would be brother or sister or a spouse of a child. They're Class C beneficiaries. Unfortunately, they only receive a $25,000 exemption, and then the rates start at 11% and go up to 16% depending on how much you're leaving each Class C beneficiary. All right, these rates apply to essentially all of your assets except for a few exemptions such as life insurance. So please keep in mind, for most people, their two major assets are their house and their retirement plans, whether they're in an IRA, a 401k, 403b, so on and so forth. All those assets are subject to this tax. All right, so if you're planning on leaving your home and your retirement accounts to somebody other than a spouse or a child, you at least need to be aware that there's going to be a New Jersey inheritance tax on those assets. Everybody else is a Class D beneficiary for purposes of the New Jersey inheritance tax. So who are we talking about here? Friends, distant relatives, nieces, nephews, cousins, and so forth. They're all going to be Class D beneficiaries. They get a $500 exemption. However, if you leave them $500 or more, there's no exemption, and the tax applies right down to $1. It's 15% of the first 700,000, and for some reason they decided to tax an additional percentage if you leave more than 700,000. So again, this tax would apply to your home, your retirement accounts, and the majority of your assets. There are some exemptions that depend on, for example, real estate that's situated outside New Jersey may not be subject to this tax depending on how it's held. There's also no tax on life insurance in certain circumstances. So it's important, again, that you keep these New Jersey taxes in mind, particularly because, again, we're starting to see boomers that have no children. All right, so for the spouse, not an issue, right? If you want to leave your spouse 100% of your estate, that's fine. There's no inheritance tax. But when your spouse subsequently dies, now there's very likely to be an inheritance tax on your estate. So something you need to keep in mind if you don't have any children. Another issue is unmarried couples. All right, so if you have a couple that's not married, your partner is going to be a Class D beneficiary. So for example, if you put your partner on your house and you're now joint owners of the house, it's possible that at least half the house and perhaps the full value of the house, depending on when the transfer occurred, is going to be included in your taxable estate. So when you're leaving your partner your home, they're going to be a D beneficiary, and they're going to pay 15% of the value of the house, which doesn't sound like much when we're just kind of talking about it here in the abstract. But let's just say your house is worth 400,000 or 500,000, which isn't too out of line for the way real estate values are going in New Jersey. So for a $500,000 house, 15%, that's $75,000. So, do you want a partner to pay $75,000 in inheritance tax just to receive the house where you live? Probably not. Same thing's going to apply to your IRA. If you leave a unmarried partner or distant relative, your IRA, they're likely to be a Class D beneficiary, and they're going to pay 15% of the date of death value of that IRA. Now, you may think, well, I have a traditional IRA and there's an income tax embedded in that, and you're correct. But unfortunately, you don't get a deduction or an exemption on this tax for that embedded income tax. So just say your IRA is worth, again, $500,000. There's going to be a potential inheritance tax if you leave it to a D beneficiary of $75,000, right? So where are they going to pull the money to pay for that? They're likely to go into the traditional plan and remove $75,000. Well, what have they just incurred? They've just incurred $75,000 in income, even though they're paying that money to pay the inheritance tax. And now you're going to owe income taxes on that as well. So as you can see, the taxes do take a significant bite out of some of these assets. And it's important that you're aware of what that is. And if possible, if there are any ways of reducing or attempting to minimize what those taxes might be. Okay. Another important tool to keep in mind are your annual exclusion gifts. So I'm using $18,000 per person per year here. We don't know, what that exclusion amount's going to be in future years. So this is a hypothetical, right? But let's just suppose it stays at $18,000, right? And you want to make gifts. And what I'm trying to demonstrate here is if you use the annual exclusion gifts every year, you can actually move a significant amount of assets out of your estate. So in year one, if it's just one person making the gift, you can transfer $18,000 per recipient. All right, so if you have 2 children, you can give $18,000 to each. All right, if you're married, you can gift split. So husband and wife, for example, could leave $36,000 to each of the children. I just have here a single recipient, so you just see 36 in year one. But if you have 2 children, you could multiply 36 by 2 and move out 72,000. So as you can see, if you do this year after year after year, you can move a significant value out of your estate. And that doesn't even account for appreciation. One of the benefits of doing lifetime gifting, particularly if you stay below the annual exclusion amount, is that you can get the future appreciation of these assets out of your estate too. Because remember, going back to the rule of 72 that we talked about, if you just earn 7% on the $18,000 you gave in year one, not only have you given the recipient the $18,000, they invested properly, over the course of 10 years, they may wind up with $36,000, because that gets not only the underlying asset out, but it also gets the future appreciation of that asset out of your estate. So it's an important tool to keep in mind. If you want a gift split, again, assuming absolutely no appreciation, you can see in the far right column that you can move a significant amount out of your estate. If you're thinking about engaging in this type of planning, it's important to at least consult with your CPA if you have one, and your financial advisor. Also our office is available to discuss with you various options. Probably one concern that you're thinking about as we go through these numbers is if I leave an outright gift to a child or a grandchild, particularly if they're a minor, how is that structured? So there are ways of addressing that, whether it's a uniform transfers to minors account, or our office, we could do a minors trust. that could handle the assets until they're older. So there are options for addressing that. And again, if you're thinking about moving significant amounts of money, here we have on the slide, you can see this adds up quickly. It may be very worth your while to consider a trust option, particularly if the individual is a minor, or at the very least, uniform transfers to minor's account. All right, so we've talked about taxes. And just to summarize them before we move off, there's a federal estate tax of $13.16 million exemption, right? So if your estate is over that exemption amount, you're going to pay federal estate tax, depending on who you leave the assets to. Again, if you leave them all to a spouse, there's no tax. But if you're planning on leaving more than that amount to children or grandchildren, there's a potential tax involved, and you really ought to be consulting with a professional as to see what ways there are to address or minimize those taxes. All right. So at the federal level, there's a combined exemption of 13.16 that's going to be indexed for inflation next year. Excuse me. In 2025, that exemption is going to sunset. So if nothing's done in terms of legislation, it's very likely that exemption is going to be roughly cut in half. We're not sure exactly where the number will be. That'll be determined later by the IRS, but good rule of thumb is to envision that it's going to be about half an exemption for what you have now. There's no estate tax at the New Jersey level, but there is the inheritance tax that we ran through a minute ago. If you're going to leave your assets to a spouse, child, or grandchild, then the New Jersey inheritance tax is probably not a concern for you. If, again, you're unmarried, or if you don't have children, then the inheritance tax is something that you need to think about, particularly if we're talking about a surviving spouse and where the assets will pass after the surviving spouse also dies. So those are the federal and estate death and inheritance taxes. Very important to think about, and that your documents be able to address any changes regarding those exemptions in the future. So let's talk about some major non-tax issues in estate planning that might be facing boomers. All right. A major one that comes up in many of our discussions is what happens to my estate after I leave it to a beneficiary. One concern that people have is that the estate passes not necessarily to the beneficiary, but what happens if the beneficiary dies or if there's a divorce? All right, so here's a slide that can demonstrate at least some scenarios related to this issue. So here we have a decedent that leaves an inheritance to a beneficiary. If the beneficiary subsequently dies, or if there's a divorce, it's likely that at least some of these assets may wind up with the surviving spouse. That's particularly the case if the beneficiary dies and they just have a simple estate plan that leaves 100% of their assets to a surviving spouse. All right. In the case of a divorce, inheritance, depending on what state we're talking about, receives some protections. However, even in New Jersey, for example, where you have statutes on the books that address inheritance as being separate property for purposes of a divorce, there are handling issues, for example, as to how that inheritance was handled during the marriage that can affect that. So, for example, if your beneficiary takes the inheritance and then transfers the inheritance into a joint account with their spouse at that time, it's likely that if there's a divorce, the spouse is going to try and include that inheritance for purposes of equitable distribution between the spouses. There are also issues of how the income is being handled from the inheritance, which can be a little technical. But all I want to convey to you for purposes of this presentation is that it's very important how the inheritance is handled, and depending on what your beneficiary does with the inheritance, could be on the line if there is a divorce, and it's also highly likely that the inheritance would simply pass to a surviving spouse. I'll give you an example right here on the slide as to why that can be an issue, even if there isn't a divorce. So let's just suppose our beneficiary dies, all right, and then your inheritance gets included in the beneficiary's estate, and that now passes to their surviving spouse. All right, so particularly if the surviving spouse is younger, there may be a remarriage, right? So the surviving spouse may find a new spouse, which is some person that you had no idea who they were during your lifetime. But now your beneficiary has died and his or her spouse is now remarrying, right? And your assets are involved. All right. This could be particularly an acute issue if the spouse then subsequently dies. So now all the assets, depending on how the plan's structured, could be passing to this, quote, new spouse, end quote, which is again an individual that you have no idea who they were during your lifetime. So there are risks involved in just passing your inheritance outright to a beneficiary, particularly if there is a death or divorce. I guess in particular, if the beneficiary dies earlier in life. All right. Another type of issue involving inheritance is if it's passed outright to a beneficiary. All right. Now, for many people, they may just say, I'm going to leave my assets outright to the beneficiary, and then I always like it. They always say, money's going to do this, and the money's going to do that, and X, Y, Z, right? Well, my rule of thumb is money doesn't do anything, right? It's inert. It is not living. It sits in an account, and the beneficiary tells the money what's going to happen. All right. So if the beneficiary cannot manage their inheritance, you're living in a dream world if you pass it to them outright. All right. It's very likely that the inheritance is going to be squandered. If they have a gambling or a spending problem, they're going to run through that inheritance really quickly on credit cards, vacations, gifts to their friends. I put in there other. I'll explain to you what a couple other items are. Unfortunately, in today's society, other can mean an addiction issue. If you have a beneficiary that does have an addiction issue, then think very carefully about how you want to handle the inheritance. You may actually be doing them a disservice and them being the beneficiary by leaving them an inheritance, because that money is just going to be spent on the addiction, right? And it's going to fuel the addiction and leave the beneficiary in a worse place than they would have been if you hadn't given them any money. So there are some issues with your beneficiary, particularly if they have spending problems or dependency issues. Another issue I'm going to add in here, which you don't see on the slide, is if your beneficiary is a minor. So that's somebody who's under 18, certainly, or if they're young. All right, so we'll talk about beneficiaries that are under 18. The primary issue with leaving inheritance to individuals who are under 18 is that they can't handle them, right? In New Jersey, it's likely that that money is going to go to the surrogate's office, right? And it's going to sit in the surrogate's commingled fund if you leave it outright to a beneficiary who's a minor. Just not going to happen. If it's a retirement account, for example, and you name a minor, well, that's fine. But the issue then becomes, particularly if this is like a grandchild, for example, the child's parents are going to have to be bonded for that asset, even though there aren't any issues in the family. So again, naming a minor isn't such a bad thing, particularly on a retirement account, but bad being it's better than nothing. It can pose issues, right, and cause unnecessary expenses. So if you have a minor involved, in my opinion, you absolutely have to have a trust for them. And that trust is going to last as long as you want. There are different options for how long that trust can continue, but you absolutely have to have a trust, because otherwise, your options are pay the money to the surrogate, number one, which isn't great. It's better than nothing, but that's option number one. And option number two is likely the minor individual's parents are going to have to be bonded for the asset, which is just going to be thousands of dollars thrown out the window. So that's an additional issue in terms of leaving inheritance outright to a beneficiary that needs to be addressed in your documents. All right. So in lieu of leaving assets outright to beneficiaries, you can create trusts for them. The trust can appear either in your will, or as we mentioned earlier, you can do a revocable trust. So your estate would flow into the revocable trust, and then potentially, as you see here on the slide, it can be subdivided into sub-trusts for the children or grandchildren. All right, and there are lots of benefits of a trust. It allows, in the case of an individual who can't manage money, the appointment of a trustee to assist the beneficiary in managing the money. And it also allows that trustee the discretion to determine when distributions should be made from the trust, either directly to the beneficiary, or the distributions may be more appropriately done by direct payment of expenses, education, medical, and so forth for the beneficiary. So the trust does have a lot of nice options. If you don't have a plan in place, it's certainly something that you should consider, particularly for minors, or if the divorce is an issue, or the taxes can implicate your estate, as we talked about earlier. All right, just kind of blowing up one of those sub-trusts that we saw on the previous slide. There are lots of different ways to do distributions from the trust to the beneficiaries. Here are just a few. The sub-trust can provide income and principal distributions to the child, who's the primary beneficiary, and it can also allow for discretionary distributions for the next generation. Here are the grandchildren. All right, in case, for example, they want to use the money for education or so forth, it can be accessed from the sub-trust. So there are lots of different ways of structuring the trust to benefit not only children, grandchildren, and your heirs if you don't have children. So it's important that you at least understand what these options are and how they can be used to benefit your heirs. Okay. So in conclusion, we've discussed a few of the, quote, new issues that face baby boomers. Again, in a nutshell, some of those issues are an aging population that can become vulnerable to fraud. It can become vulnerable to aggressive family members that are seeking to modify a plan or gain access to the money. There are a number of issues that unfortunately are facing some of our older members of our society. And it's important, not only as a general matter, that you have an estate plan, but because of these new issues, that you get a plan in place, particularly now while you have capacity, as opposed to waiting until later in life, and then the expenses are hitting, perhaps you're faced with some of these fraud scenarios and so forth, and makes it more difficult to get the documents in place. We discussed some of the federal and New Jersey estate gift and inheritance taxes that may or may not be need to be addressed as part of your plan. And we also noted that there are major non-tax issues related to the estate plan. So between the taxes and the non-tax issues, it's likely that at least one, perhaps more of these various issues is going to affect your plan. And it's important that you understand what your trust planning opportunities and options are. And if you're not interested in a trust, certainly what your will, power of attorney, and related documents can provide for you. If you have any questions, as I mentioned in the beginning of the seminar, please feel free to call me. My phone number is here on the slide. I'll just read it off for you. It's 609-945-7617. I'm happy to generally discuss things with you. If you'd like, I'm available for consultations also regarding these issues, where we can dig into some of them as they may affect you on an individual basis in accordance with your unique circumstances. And you'll see here on the slide my email. Please feel free also to reach me via email at rmorris@stark-stark.com. I want to thank you for joining us here today, and I wish you well.